Hello everyone, my name is Dr. Swati Singh. I am Assistant Professor, School of Management, Maharaja Hussain University. Today I am going to discuss the topic offer and acceptance with you all. So let's start. First of all, we are going to discuss what is an offer. Starting with the meaning of an offer, offer is the starting point in the making of any agreement. Offer is also known as proposal, and when it comes to the definition, according to Indian Contract Act 1872, um, offer is defined under section 2 subsection A. It is defined as when one person signifies to another its willingness to do or abstain from doing anything with a view to obtain the assent of other to such an act or abstinence, he is said to make a proposal. So, in the definition, offer signifies that one person is signifying his willingness to another person. The main objective is to obtain the assent of the other person to whom offer has been made. Next is essential elements of an offer. Uh, for the essential element, first is two parties. There must be one person who is making an offer to the another person. So there must be two parties available when it comes to making an offer, and one person cannot make an offer to himself or herself. Second is communication. The offer must be communicated to the offeree. Here, when we are talking about communication, communication is very necessary. If the communication is not done, the offer cannot be accepted and no valid contract will be formulated. Next is willingness. Here, the offer must show the willingness of the offerer. Mere, telling or sharing a plan of yours is not considered as making an offer. Fourth is with the intention of obtaining the assent. So whenever the offer is being made, the offer should be made with a view to obtain the assent of the offeree. The offerer cannot make a valid offer until he has the intention of obtaining the assent of the other party. In order to make an offer to be valid one, this particular essential element is very necessary to be present. Next is the offer may be positive or negative. As we have already discussed in the definition part, that offer may involve doing something or not doing something. When we are talking about offer to do something, it is termed as positive offer. When we are saying that the offer is not to do something, it is known as negative offer or negative act. I can give you an example. When we are talking about the positive offer, a person is making an offer to the other person regarding the sale of a particular item or product. For example, A is making a proposal to sell a TV. So here, selling a television is basically a positive offer. When we are talking about the negative offer, for example, A is proposing or A is making an offer to B that if he does not file a suit against A will give him rupees 1 lakh rupees. So this is basically an offer where A is making an offer not to do something or not to file an suit against him for defamation or any reason, and he'll be giving him some certain amount of consideration or money. This kind of proposal is to abstain from doing something, so it is known as a negative proposal. The parties who are involved in making an offer or accepting an offer, the person who is making the proposal is known as an offerer or proposer, whereas the person to whom the proposal is made is known as or called as offeree or proposer. Next is the classification of an offer. An offer can be classified into various categories. First is express offer. Express offer is something which is either in the spoken words or can be written. So here the offerer may express or may make a proposal verbally or in the written form. For example, A communicates or offers to B, like, will you purchase my laptop for worth rupees 30,000? So here the person A is making an offer in spoken words, or he's making an offer verbally, and he's also mentioning the um, price at which he is willing to make an offer. So this is an example of express offer. Whereas when we talk about the implied offer is something which can be understood through the conduct of the parties, or through the situation of a particular case. So that is known as an implied offer. For example, for implied offer, we can take an example. A is at the bus stop, and a bus comes and stops at his place of stop. So here the bus company or the driver is making an offer. He has not spoken a word, he has not communicated anything, but he has just made a stop in front of that particular person who was waiting for the bus. So this is an example of implied offer, where the person or parties do not have to exchange words. It will be conducted, or it will be understood through the conduct of the parties who are in the contract. Next is the general offer. When we talk about the general offer is something which is an offer which is made to a general public rather than a specific person. The offer which is made to the world at large, and any person out of that general public can accept the offer. So that is an example of general offer. For example, we can take the example of initial public offers. When initial public offers are made by the companies, they um, display the advertisement in the newspapers, and the whosoever person is interested in that IPO or initial public offer, they can fill the form, they can apply for the shares. So that could be example of general offer. We can also take one more example. For example, a person has lost his pet. For searching that pet, he makes an advertisement in the newspaper. So he makes an offer that whosoever finds his pet, he'll award them rupees 10,000. So here also the offer is made to the general public. He has communicated what reward the person will get if he finds his pet. In case whosoever finds his pet, he will be awarded with that amount of money which was promised by the person. So general offer can be explained in the form. Then we have specific offer. Specific offer is something which is totally opposite to the general offer. Specific offer, here offer is made to a specific person or particular person, and the person to whom the offer is made has to be accepted by that particular person. So specific offer is generally made to the as certain persons. For example, A says to B that, will you purchase my house for worth rupees 10 lakh rupees? So it is a specific offer being made to B, and B only is eligible to accept that particular offer. Then we have the example of, then we have, next is cross offer. Cross offer, here two parties are making an offer to one another, but they are ignorant about the offer made by the other party. The terms and conditions in cross offer, which are made by the both the parties, are same. So in cross offers, basically, we can take an example. For example, A is offering to sell 10 tons of wheat to B at rupees 1,000 per ton. On the same day, B also makes the same offer to A, where he is offering to buy um, 10 tons of wheat at rupees 1,000 per ton. So both the parties are making the cross offers, where one party is making an offer to sell a product at the same price of same quantity, and on the other hand the other party is also interested in buying the product which is of same quantity and is also offering to buy the product at same price. So this is an example of the cross offer. Next we have the continuous offer. Continuous offer is a kind of offer which is open for a continuous period of time, and it is also known as open offer or standing offer. Basically, it is a kind of here we can take an example of tenders to buy products or tenders to sell certain product. So here, when we are buying or selling or supplying goods as and when required, this can amount to standing offer or continuous offer. Then we have an example of counter offer. Counter offer is basically an offer made by the offeree in return to the original offer. So that kind of offer is termed as counter offer. Here we can take an example. A offers to B to sell his pen for worth rupees 100. B says that I'm ready to buy this particular pen but not at 100, but I'll pay only 90 rupees. If A accepts his offer, in that case the original offer that was made by A will be cancelled here and it will be rejected, and new offer will be formed where um, B was offering to buy that particular product at 90 rupees. So here the original offer will be cancelled, but the new offer will be created where here the uh, parties will be exchanged. For example, in first case where A was making an offer to B, A was offerer and B was offering. When A accept the proposal of B, the B will become the offerer and offeree will be A. So this is an example of counter offer. Next are the legal rules as to offer. As we have already discussed, offer is the starting point of a contract or an agreement. So when we are talking about the validity of a offer, if the offer is not valid, the contract is not going to be a valid contract. So first point that I'm going to discuss is the offer should not bind the other party to reply. Your contract or your proposal should not in such a way that you are making a binding of the other party to make a reply. For example, if a person has mentioned or they have sent the email making a proposal where the person is making an offer to sell his laptop worth rupees 30,000, and here he also adds terms and condition that if the person to whom the offer is being made, he does not reply within 15 days, the offer will assume to be accepted. This cannot be a case, and you cannot add such kind of conditions where non-acceptance or no reply means the acceptance of the offer. Second point is offer must be definite, unambiguous and certain. The terms of the offer must be definite, it should be clear, it should be certain. Um, Nothing can be vague. If you want the contract to be a valid contract, every proposal's condition should be made clear to the person to whom the offer is being made. Next is invitation to offer is not an offer. When we talk about invitation to offer, it is something where the person is intending to put a proposal. It does not amount to be an offer. For example, the price list of the goods and services for sale, it's just a proposal or invitation of the proposal, not a proposal. We can also take an example, for example, a company who is inviting public to apply for the share, and they are making an invite through the prospectus. So it is also an invitation to put the offer to buy the shares. Here the person is not interested in making an offer, but it is an invitation to offer. So likewise, there could be number of examples where, for example, you go to a shop and certain items are being displayed with their price tag. So it is also an invitation to the proposal. And if the salesperson is not accepting the price, and the person who is buying those, or he is interested in buying those product or goods, he cannot force them to sell the product at that particular price. Next, we have terms and conditions communicated along with the offer. So, whenever the offer is being made, the terms and conditions regarding that particular offer should be communicated to the offeree, so that it gives a full opportunity to the person to make a decision based on that. And it is very important for the offerer and offeree to prepare or to create the terms and conditions clearly and inform that either before the time of making an offer or at the time of making an offer. So it is all about the concept of offer. Now we are moving forward towards the next concept, that is meaning of acceptance. Now acceptance is giving the consent to the offer. It is an expression by the offeree of his willingness to be bound by the terms of the offer being made by the offerer. The acceptance is defined under section 2B of Indian Contract Act, and it has been defined as a proposal or offer is said to have been accepted when the person to whom proposal is made signifies his assent to the proposal to do or not to do something. Next are the essential elements of the acceptance. Acceptance, first point is acceptance must be absolute and unqualified. Here, when we are talking about unqualified means something unconditional. Acceptance must be for the whole offer, including all the terms and conditions, if any. You cannot make acceptance with certain conditions, that you are going to accept these terms and conditions and you cannot accept the other one. So whenever the acceptance is made, that must be made to whole of the offer, including all the terms and conditions. Second is acceptance must be communicated. When we are talking about communication, your acceptance in your mind is no acceptance. You have to communicate whether you accept to the offer, whether you accept the terms and conditions made by the offerer to you. So communication is very important, but there are certain exceptions. For example, in when the person is making a general offer. In case of general offer, there is no requirement to make an communication to the acceptance. You can perform the particular condition, you can perform whatever has been mentioned in the general offer, and it will be considered as accepted. Then is manner of acceptance. When we are talking about acceptance, certain rules have been mentioned by the offerer, how the communication of acceptance is to be made, how the person should accept the offer. So general rule says that whatever the manner has been prescribed by the offerer, the offeree should accept the terms and condition or offer in the same manner as prescribed by the offerer. If the offerer has not prescribed any mode, it can be accepted by any usual or reasonable manner. If there is any kind of deviation in communication of the acceptance of the offerer may reject such kind of acceptance. For that, he has to send a notice within a reasonable period of time. Next is acceptance of offer must be from competent person. Uh, Competent person is a person who is competent enough to enter into a contract. So acceptance of offer must come from a person who is a competent person to enter into a contract. The person who has attained the age of majority, the person who is of sound mind, the person who has not been disqualified by any law to enter into any contract, the acceptance can come from the person who is competent person. Next is time limit for acceptance. In general, is the time limit may be mentioned in the offer. So if the offer prescribes the time limit, it should be accepted within the specific time. But if the offer does not prescribe the time, it must be accepted within a reasonable time. Acceptance may be in express or implied form, as we have already discussed in case of offer. The acceptance may also be in spoken or on written words. Um, Mere silence is not acceptance of an offer. Silence, when we are talking about the acceptance also has to be in express or implied form. If the person is not replying or responding to one's offer, in that case we can say that offer cannot be created between two persons, because here the person is not responding or not replying. For example, A makes an offer to B to buy his house for worth rupees 10 lakh, and he writes that he wants to sell his house. um, but in that case, the person to whom being offer is being made, he is not responding or replying. The contract cannot be formed between A and B. Next is acceptance subject to contract is no acceptance. When we are talking about acceptance, if the acceptance should be given in the full form to all the terms and conditions, if the acceptance has been given subject to contract or subject to approval by certain person, it means that the contract is still in the negotiation phase, and we need to in order to create a binding between the contract, all the terms and conditions have to be accepted. If such acceptance is not made, it will not create any kind of binding between the two parties. Next, we are going to discuss the general rules as to communication of an acceptance. In case of um, acceptance, the acceptance has to be communicated, and certain rules and regulations have to be followed for the communication of the acceptance. First, that next is general rules as to communication of acceptance. In case of acceptance by post, where the acceptance is given by the post, the communication of offer is completed as against the offerer when the letter of acceptance is posted. Next is delayed or no delivery of the letter. When the person who has accepted the offer has posted the letter, but it does not reaches the person to the person who has made the offer, that is offerer, or it is delayed in the transit, in that case it is not going to affect the acceptance or its validity. The offerer is bound to accept the offer, or is bound by the acceptance which has been made by the offeree. Next is acceptance by telephone, telex, or any fax. If the communication of acceptance is made by these forms of communication modes, um, in that case, the acceptance will be completed when it has been received by the offerer. Next is place of contract. In case of acceptance by post or place where the letter is posted, the place of contract will be considered as the letter where it has been, where the acceptance is given by the modes of communication like telephones, etc. In that case, the place of contract will be the place where the person to whom the communication is to be made about the acceptance, it has been received. Next is the time of contract. Time of contract is very important in case of acceptance. In case of acceptance by post, the time of posting the letter of acceptance will be considered as the time of contract. And in case of acceptance by any other mode like telecommunication, The time of contract is the time when the offerer gets the communication of the acceptance. I hope you have learned a lot. This is all about the offer and acceptance, and what are the essential elements of offer and acceptance, and what are the different rules which are necessary so that it is considered as a valid offer and valid acceptance. Thank you so much.